Picture this, a world where humanity no longer sees the stars as distant, unreachable lights, but as destinations teeming with opportunity. A world where private companies mine asteroids for rare metals, nations establish colonies on the moon, and Mars becomes a second home for humankind. This isn't science fiction, it's the future we're racing toward. But here's the catch: as we venture further into the cosmos, who gets to own what? Who makes the rules when Earth's laws no longer apply? The growing importance of space exploration is undeniable. From lunar bases to asteroid mining, the possibilities are endless, but so are the challenges. Without clear legal frameworks, the final frontier could become a chaotic free-for-all, where disputes over ownership and resources could spark conflicts that ripple back to Earth. That's why the future of space law and ownership rights isn't just a niche topic for scientists and lawyers. It's a conversation that will shape the destiny of humanity. In this video, we'll dive into 25 in-depth predictions about the future of space law and ownership rights. From the rise of international space governance bodies to the legal battles over lunar property rights, we'll explore how humanity will navigate the complexities of claiming and managing what lies beyond our planet. By the end, you'll not only understand the challenges ahead, but also see why this evolving field is crucial to ensuring a fair and peaceful future in space. So, buckle up and get ready to explore the legal frontiers of the cosmos. The rules we create today will determine whether space becomes a new era of cooperation or a battleground for the stars. Let's begin. Now, let's turn our attention to the first prediction, the rise of space governance bodies. As humanity expands its reach into the cosmos, the need for clear, enforceable rules becomes undeniable. Imagine a future where multiple nations and private entities are operating in space simultaneously, mining asteroids, building lunar bases, and launching satellites. Without a unified framework, this could quickly descend into chaos. That's where international space governance organizations come in. These bodies will likely emerge as a response to the growing complexity of space activities. Think of them as the United Nations of space, but with a focus on regulating everything from resource extraction to satellite traffic. Their structure will need to balance the interests of powerful nations, private corporations, and smaller countries to ensure fairness and cooperation. One of the biggest challenges will be creating a system that's flexible enough to adapt to rapidly evolving technologies while remaining robust enough to prevent exploitation or conflict. The potential impact of these organizations is enormous. By fostering global cooperation, they could help avoid the kind of territorial disputes that have plagued Earth for centuries. For example, a well-designed governance body could establish clear guidelines for lunar mining, ensuring that resources are shared equitably rather than monopolized by a few. At the same time, these organizations will need to address thorny issues like enforcement. How do you penalize a company or nation that violates space laws when there's no police force in orbit? This prediction isn't just about creating rules, it's about shaping the future of humanity's relationship with space. The success of these governance bodies will determine whether we see space as a shared frontier or a new arena for competition. And as we'll see in the next prediction, private companies are already playing a major role in shaping this future. Now, shifting our focus to the next frontier of space law, let's dive into the growing influence of private companies on space ownership rights. As we've seen with pioneers like SpaceX and Blue Origin, the private sector is no longer just a participant in space exploration, it's becoming a driving force. These corporations are not only launching rockets and satellites, but also laying the groundwork for ambitious projects like lunar bases and Mars colonies. But with this rapid expansion comes a pressing question: who owns space, and how will private entities shape the rules of the game? Private companies are already challenging traditional notions of space ownership. Unlike nations which operate under treaties like the Outer Space Treaty of 1967, corporations are pushing for clearer legal frameworks that allow them to claim and profit from extraterrestrial resources. For instance, asteroid mining is no longer a sci-fi fantasy. It's a real possibility, and companies are eager to stake their claims, but this raises complex legal questions. Can a private company own an asteroid? And if so, how do we ensure that these resources are shared fairly rather than monopolized by a few wealthy entities? Legal battles are inevitable as private companies and governments clash over these issues. We're likely to see a wave of lawsuits and negotiations as corporations seek to establish their rights in space. For example, if SpaceX sets up a mining operation on the Moon, who has jurisdiction over that site? Will it be governed by U.S. law, international treaties, or a new set of rules entirely? These disputes could lead to the creation of new treaties or amendments to existing ones, reshaping the legal landscape of space for decades to come. At the same time, private companies are also influencing space law through innovation. By developing cutting-edge technologies and infrastructure, they're forcing governments to rethink outdated regulations. For instance, the rise of reusable rockets and private space stations is challenging traditional models of space governance. As these technologies become more common, we'll need new laws to address issues like safety standards, liability, and environmental protection in space. The role of private companies in space ownership is a double-edged sword. On one hand, their ambition and resources are accelerating humanity's reach into the cosmos. On the other hand, their pursuit of profit could lead to conflicts over resources and power. The challenge for lawmakers will be to strike a balance, encouraging innovation and investment while ensuring that space remains a shared frontier for all of humanity. As we'll see in the next prediction, this tension between private interests and collective ownership will play out in even more dramatic ways as we look to the Moon and beyond. Now, let's turn our attention to the Moon, where the next chapter of space law is already being written. As humanity sets its sights on lunar exploration and development, the question of who owns the Moon or parts of it becomes increasingly urgent. Unlike the vast emptiness of space, the Moon offers tangible resources and real estate, making it a prime target for both nations and private companies. But how will property rights on the Moon be defined, and who gets to decide? The Outer Space Treaty of 1967 states that no nation can claim sovereignty over celestial bodies, including the Moon. However, it doesn't explicitly address private ownership or resource extraction. This legal gray area has opened the door for ambitious projects, like lunar mining for rare minerals or the establishment of permanent settlements. Nations and corporations are already positioning themselves to take advantage of these opportunities, but the rules of the game are still being debated. One possibility is the creation of a lunar land registry, similar to how property is recorded on Earth. This system would allow entities to stake claims on specific areas of the Moon, provided they meet certain criteria, such as demonstrating the ability to develop the land responsibly. For example, a company planning to mine helium-3, a valuable resource for fusion energy, might be granted rights to a particular crater, but this raises questions about enforcement. Who will ensure that these claims are respected, and what happens if two parties claim the same territory? Another challenge is balancing national interests with international cooperation. While some countries may push for exclusive rights to lunar resources, others will advocate for a shared approach, ensuring that the benefits of lunar development are distributed equitably. This tension could lead to the creation of new international agreements or even a dedicated lunar governance body. Such an organization would oversee activities on the Moon, from mining operations to the construction of research stations, ensuring that all parties play by the same rules. Private companies are also likely to play a major role in shaping lunar property rights. For instance, if a corporation builds a lunar base, does it own the land beneath it? Or does it merely have the right to use it? These questions will need clear answers to avoid conflicts and encourage investment. At the same time, we'll need safeguards to prevent the moon from becoming a free-for-all, where only the wealthiest entities can secure valuable resources. The potential for lunar settlements adds another layer of complexity. Imagine a future where people live and work on the moon. Who governs these communities? Will they operate under the laws of the country that established them? Or will they develop their own legal systems? And what about the rights of individuals living there? These are just some of the questions that will need to be addressed as we move closer to making the moon a second home for humanity. As we look ahead, it's clear that lunar property rights will be a cornerstone of space law in the coming decades. The decisions we make today will shape how we explore, develop, and share the moon for generations to come. And as we'll see in the next prediction, these challenges will only grow more complex as we set our sights on Mars and beyond. Now, let's shift our gaze from the moon to the red planet, where the stakes are even higher. Mars colonization represents the next frontier in humanity's quest to become a multi-planetary species, but it also brings with it a host of legal challenges that will shape the future of space law. Unlike the moon, Mars is a planet with its own unique environment, resources, and potential for long-term habitation. This raises critical questions about sovereignty, resource allocation, and the rights of individuals living in extraterrestrial environments. One of the most pressing issues is sovereignty. The Outer Space Treaty prohibits nations from claiming ownership of celestial bodies, but it doesn't provide clear guidelines for how to govern a colony on Mars. If a nation or private company establishes a settlement, does that give them control over the surrounding area, or will Mars be governed as a shared resource with international oversight? These questions will need answers to prevent conflicts and ensure that Mars is developed responsibly. Resource allocation is another major challenge. Mars is rich in resources like water ice, which could be used to support life and fuel future missions. But who gets to extract and use these resources? Will they be shared equally among nations, or will the first to arrive have the advantage? This could lead to a race to Mars, with countries and corporations competing to secure the most valuable sites. To avoid this, we may need new treaties or agreements that establish fair rules for resource use and distribution. Human rights on Mars present a unique set of legal questions. Imagine a future where thousands of people live and work on the red planet. What laws will protect their rights? Will they be subject to the laws of their home country, or will Mars have its own legal system? And what about issues like freedom of movement, labor rights, and access to essential resources? These are not just theoretical questions, they will have real implications for the people who call Mars home. Another layer of complexity comes from the potential for private companies to play a leading role in Mars colonization. If a corporation builds a settlement, does it have the authority to govern it? And how will disputes between private entities and governments be resolved? These questions highlight the need for a robust legal framework that balances the interests of all stakeholders, from nations to corporations to individual colonists. As we look to the future, it's clear that Mars colonization will require a new approach to space law. The decisions we make today will set the stage for how humanity explores and inhabits the red planet. And as we'll see in the next prediction, the challenges of space law extend far beyond Mars, into the vast reaches of our solar system and beyond. Now, let's venture beyond Mars and into the asteroid belt, where a new frontier of opportunity and legal complexity awaits. Asteroid mining has the potential to revolutionize our access to rare and valuable resources, but it also raises significant questions about ownership, regulation, and profit sharing in space. As nations and private companies set their sights on these celestial bodies, the need for clear and fair asteroid mining laws becomes more urgent than ever. One of the biggest challenges is determining who has the right to mine an asteroid. Under the Outer Space Treaty, no nation can claim sovereignty over a celestial body, but the treaty is less clear about the extraction and use of resources. This ambiguity has led to debates about whether a company or country can own the materials they extract from an asteroid. Some argue that the first to mine a resource should have ownership rights, while others advocate for a system that ensures equitable access for all nations. This tension could lead to disputes unless new agreements are established to clarify these rights. Profit sharing is another critical issue. Asteroids are rich in precious metals like platinum, as well as resources like water that could support future space missions. If a company or nation successfully mines these resources, how should the profits be distributed? Should there be a global fund to support space exploration and development, or should the benefits remain with the entity that invested in the mining operation? These questions will require careful negotiation to balance the interests of private enterprises with the broader goals of humanity's advancement in space. Another layer of complexity comes from the environmental impact of asteroid mining. While asteroids may seem like barren rocks, they are part of a delicate cosmic ecosystem. Mining activities could alter their orbits or create debris that poses risks to other spacecraft. To address this, future regulations may need to include environmental protections that minimize harm to space environments and ensure the long-term sustainability of asteroid mining. The role of international cooperation will be crucial in shaping asteroid mining laws. Unlike Earth-based resources, which are often governed by national laws, asteroids are a shared resource that requires a global approach. Organizations like the United Nations or new space governance bodies could play a key role in creating frameworks that promote collaboration and prevent conflicts. This could include establishing licensing systems, setting environmental standards, and creating mechanisms for resolving disputes. As we look to the future, asteroid mining represents both an incredible opportunity and a significant challenge for space law. The decisions we make today will determine how we harness these resources and whether we do so in a way that benefits all of humanity. And as we'll explore in the next prediction, the challenges of space law extend even further into the realm of managing the growing traffic in Earth's orbit. As we shift our focus from the challenges of asteroid mining, another pressing issue emerges in the realm of space law: the growing congestion in Earth's orbit. With thousands of satellites already in operation and plans for even more to be launched in the coming years, the need for effective space traffic management has never been more critical. Imagine Earth's orbit as a bustling highway where satellites, space stations, and debris all share the same space. Without proper coordination, the risk of collisions increases, potentially causing catastrophic damage and creating even more debris in a dangerous chain reaction. To address this, experts predict the development of advanced space traffic control systems. These systems would function similarly to air traffic control on Earth, monitoring the positions and trajectories of all objects in orbit. By using sophisticated tracking technologies and real-time data, they could predict potential collisions and issue warnings or instructions to operators to adjust their spacecraft's paths. This would not only prevent accidents but also ensure the long-term sustainability of Earth's orbital environment. One of the key challenges in creating such a system is the lack of a unified global framework. Currently, different countries and private companies operate their satellites independently with limited coordination. This fragmented approach increases the risk of misunderstandings or conflicts. To overcome this, international cooperation will be essential. Organizations like the United Nations or new space governance bodies could play a central role in establishing standardized rules and protocols for space traffic management. These rules would need to address issues like priority rights, communication standards, and emergency procedures. Another important aspect of space traffic management is the growing issue of space debris. Thousands of defunct satellites, spent rocket stages, and other fragments already clutter Earth's orbit, posing a significant threat to active spacecraft. Future regulations may require operators to take responsibility for their debris by either deorbiting it safely or moving it to designated graveyard orbits. Additionally, technologies like debris removal systems could become a critical part of maintaining a safe and functional orbital environment. As space becomes increasingly crowded, the need for clear and enforceable space traffic laws will only grow. These laws will not only protect existing infrastructure, but also pave the way for new opportunities, such as mega constellations of satellites for global internet coverage. By addressing these challenges now, we can ensure that Earth's orbit remains a safe and accessible resource for future generations. And as we'll explore next, the legal landscape of space extends even further into the realm of intellectual property and innovation beyond our planet. Now, let's turn our attention to a fascinating frontier of space law, intellectual property. As humanity ventures further into space, the innovations created in this unique environment will challenge our existing legal frameworks. Imagine a scientist developing a groundbreaking technology in the microgravity of the International Space Station. Who owns the rights to that invention? On Earth, intellectual property laws are well established, but space introduces a whole new set of complexities. One of the key questions is jurisdiction. Currently, intellectual property laws are tied to the country where an invention is created. But in space, where multiple nations and private entities operate together, determining ownership becomes less straightforward. For example, if an astronaut from one country develops a new technology while aboard a spacecraft registered to another nation, which legal system governs the patent? This ambiguity could lead to disputes and hinder innovation if not addressed. To tackle this, experts predict the creation of specialized space intellectual property laws. These laws would need to clarify jurisdiction, ensuring that inventions made in space are protected regardless of where they were developed. This could involve international agreements that harmonize intellectual property standards across borders, making it easier for innovators to secure patents and share their discoveries. Another challenge is the unique nature of microgravity. Technologies developed in space often rely on conditions that can't be replicated on Earth. This raises questions about how to patent such innovations. For instance, a manufacturing process that only works in zero gravity might require a new category of patents tailored specifically to space-based inventions. This could open up exciting opportunities for industries like pharmaceuticals, materials science, and advanced manufacturing. Additionally, the rise of private space companies adds another layer of complexity. Corporations investing heavily in space research will want to protect their intellectual property, but they'll also need to navigate international laws and treaties. Balancing these interests with the need for collaboration and knowledge sharing will be crucial for fostering innovation in space. As we look to the future, intellectual property laws will play a vital role in shaping the economic landscape of space exploration. By adapting to the unique challenges of space, these laws can encourage innovation while ensuring fair access to the benefits of new technologies. And as we'll explore next, the legal framework of space extends even further into the realm of environmental protection and preserving the celestial frontier. As we venture further into the cosmos, another critical aspect of space law comes into focus, protecting the space environment itself. Just as we've learned the importance of safeguarding Earth's ecosystems, the same principles must extend to the vast expanse beyond our planet. Space environmental protection is not just about preserving the beauty of the universe, it's about ensuring the sustainability of space activities for generations to come. One of the most pressing issues is space debris. With thousands of satellites, spent rocket stages, and other fragments orbiting Earth, the risk of collisions is growing. These collisions can create even more debris, leading to a dangerous cycle known as the Kessler syndrome. If left unchecked, this could render certain orbits unusable, jeopardizing critical infrastructure like communication satellites and space stations. To address this, experts predict the development of stringent regulations to manage and mitigate space debris. This could include mandatory deorbiting plans for defunct satellites, incentives for companies to design reusable or self-disposing spacecraft, and international cooperation to track and remove existing debris. But space environmental protection goes beyond just debris. Celestial bodies like the Moon, Mars, and asteroids are also at risk of contamination. As we explore and potentially colonize these worlds, there's a real danger of introducing Earth-based microbes or chemicals that could disrupt their natural environments. For example, if we were to discover microbial life on Mars, contaminating it with Earth organisms could destroy invaluable scientific data. To prevent this, space law will likely include strict planetary protection protocols. These protocols would govern how missions are designed, sterilized, and conducted to minimize the risk of contamination. Another area of concern is the exploitation of celestial resources. While asteroid mining and lunar resource extraction hold immense potential, they also raise questions about environmental impact. How do we ensure that these activities don't irreversibly damage celestial bodies? Future laws may require environmental impact assessments for space mining projects, similar to those used on Earth. These assessments would evaluate the potential harm to the space environment and propose measures to mitigate it. International collaboration will be key to enforcing these protections. Just as no single nation can tackle climate change alone, space environmental protection will require a unified effort. Treaties and agreements will need to establish clear guidelines for responsible behavior in space, with mechanisms for monitoring and enforcement. This could involve the creation of an international space environmental agency, tasked with overseeing compliance and promoting sustainable practices. Ultimately, space environmental protection is about more than just preserving the cosmos. It's about ensuring that humanity's expansion into space is responsible and sustainable. By addressing these challenges now, we can create a legal framework that balances exploration with preservation, paving the way for a future where space remains a shared and thriving frontier. And as we look ahead, the next frontier of space law takes us into the realm of resource sharing, where nations and companies must navigate the delicate balance between competition and cooperation. As we turn our attention to the vast resources waiting to be discovered in space, the question of how these treasures will be shared among nations and private entities becomes increasingly important. Extraterrestrial resource sharing is not just a matter of scientific curiosity, it's a complex legal and diplomatic challenge that will shape the future of space exploration. Imagine a scenario where water ice on the Moon or rare metals on asteroids could fuel entire industries back on Earth. The potential is enormous, but so are the stakes. One of the first hurdles will be defining ownership. Under current international space law, celestial bodies like the Moon and asteroids are considered the common heritage of mankind, meaning no single nation can claim sovereignty over them. However, this principle doesn't clearly address how resources extracted from these bodies should be shared. Will nations and companies be allowed to profit from what they extract, or will there be a system of mandatory resource sharing? This question is likely to spark intense negotiations, with some countries advocating for free market principles while others push for equitable distribution. Water ice, for example, is a highly valuable resource on the Moon. It can be used for drinking water, oxygen production, and even as rocket fuel. But what happens if one nation or company secures access to a particularly rich deposit? Will they be required to share it with others, or will they have exclusive rights? These are the kinds of questions that future space treaties will need to address. One possible solution is the creation of a licensing system, where entities pay fees or contribute a portion of their extracted resources to a global fund. which could then be used to support international space initiatives. Asteroid mining presents another layer of complexity. Asteroids are rich in rare metals like platinum, which are in high demand for electronics and renewable energy technologies. The potential profits are staggering, but so is the potential for conflict. If two nations or companies lay claim to the same asteroid, how will disputes be resolved? Some experts predict the establishment of an international arbitration body specifically for space-related conflicts. This body would mediate disputes and ensure that resource extraction is conducted fairly and transparently. Another challenge is ensuring that resource sharing doesn't exacerbate existing inequalities on Earth. If wealthier nations or corporations dominate space resource extraction, it could widen the gap between developed and developing countries. To prevent this, future agreements might include provisions to ensure that all nations benefit from space resources, regardless of their ability to participate in extraction activities. This could involve technology transfer programs, capacity building initiatives, or even direct resource sharing. International cooperation will be essential to making extraterrestrial resource sharing work. Just as nations have come together to address global challenges like climate change, they will need to collaborate to create a fair and sustainable framework for space resources. This could involve updating existing treaties like the Outer Space Treaty, or creating entirely new agreements tailored to the unique challenges of resource extraction in space. Ultimately, the way we handle extraterrestrial resource sharing will set a precedent for how humanity approaches the cosmos. Will we prioritize competition and profit, or will we strive for cooperation and shared benefits? The decisions we make today will shape the future of space exploration for generations to come. And as we look ahead, the next frontier of space law takes us into the realm of space tourism, where the thrill of adventure meets the complexities of liability and safety. Now, as we venture into the exciting yet uncertain world of space tourism, a new set of legal challenges comes into focus. Space tourism liability is a critical issue that will shape how companies operate and how passengers are protected during commercial spaceflights. Imagine booking a ticket to space only to face an accident or injury during the journey. Who is responsible? What legal protections exist for passengers? And how will companies ensure safety while managing risks? The first major question revolves around accountability. Space tourism companies, like any other business, will need to establish clear legal frameworks to address accidents or injuries. Unlike traditional air travel, where liability laws are well established, space tourism is still in its infancy. This means that existing laws may not fully cover the unique risks associated with space travel, such as microgravity effects, radiation exposure, or spacecraft malfunctions. As a result, new regulations will need to be crafted to define the responsibilities of companies and the rights of passengers. One potential approach is the creation of liability waivers. Passengers might be required to sign agreements acknowledging the inherent risks of space travel, limiting the company's liability in case of accidents. However, this raises ethical questions. Should companies be allowed to absolve themselves of responsibility entirely, or should there be a baseline level of accountability to ensure passenger safety? Striking this balance will be crucial to building public trust in the industry. Another key consideration is insurance. Space tourism companies will likely need to invest in comprehensive insurance policies to cover potential accidents or injuries. But how will these policies be structured? Will they cover medical expenses, loss of income, or even psychological trauma resulting from a spaceflight incident? Insurance providers will need to develop specialized products tailored to the unique risks of space travel, which could drive up costs for both companies and passengers. International cooperation will also play a role in shaping space tourism liability laws. Since spaceflights often cross national boundaries, there will need to be agreements between countries to ensure consistent legal standards. For example, if a spaceflight originates in one country but involves passengers from multiple nations whose laws apply in the event of an accident, this could lead to the development of international treaties or agreements specifically addressing space tourism liability. Safety standards will be another critical factor. Governments and regulatory bodies will need to establish rigorous safety protocols for spacecraft design, crew training, and emergency procedures. These standards will not only protect passengers but also help companies mitigate risks and avoid costly legal disputes. However, setting these standards will require collaboration between governments, industry leaders, and scientific experts to ensure they are both effective and practical. Finally, the role of space tourism liability extends beyond individual incidents. How companies handle accidents and injuries will influence public perception of the industry as a whole. A single high-profile incident could have far-reaching consequences, potentially slowing the growth of space tourism or leading to stricter regulations. On the other hand, a transparent and responsible approach to liability could build confidence and encourage more people to take the leap into space. As we look to the future, the legal landscape of space tourism will continue to evolve. The decisions made today will shape how this burgeoning industry grows and how safely it operates. And as we prepare for the next frontier, we turn our attention to another pressing issue: the militarization of space and the laws that will govern its peaceful use. As we shift our focus from the legal intricacies of space tourism, we now turn to a topic that carries profound implications for humanity's future: the militarization of space and the laws that will govern its peaceful use. The idea of weaponizing space may sound like science fiction, but it's a reality that nations are already preparing for, raising urgent questions about how to prevent conflict beyond Earth. The first challenge lies in defining what constitutes militarization in space. While the Outer Space Treaty of 1967 prohibits the placement of nuclear weapons or any weapons of mass destruction in orbit or on celestial bodies, it does not explicitly ban all forms of military activity. This legal gray area has allowed countries to develop technologies like anti-satellite weapons, which can disrupt communication networks or spy satellites, effectively turning space into a potential battlefield. The question then becomes, how do we update existing treaties to address these modern threats? One possible solution is the creation of new international agreements that explicitly ban the weaponization of space. These agreements would need to address not only traditional weapons but also emerging technologies like cyber attacks on satellites or the use of space-based lasers. Crafting such treaties will require unprecedented levels of global cooperation, as nations must balance their security interests with the collective goal of preserving space as a peaceful domain. Another critical aspect is the role of space-based surveillance in preventing conflict. Satellites already play a vital role in monitoring military activities on Earth, from tracking troop movements to verifying arms control agreements. Expanding this capability could help deter aggression by providing transparent, real-time data on potential threats. However, this also raises concerns about privacy and the misuse of surveillance technologies, highlighting the need for clear legal frameworks to govern their use. The concept of space as a common heritage of mankind further complicates the issue. If space is to be preserved for peaceful purposes, how do we ensure that all nations, regardless of their technological or economic capabilities, have equal access to its benefits? This principle, enshrined in the Moon Agreement of 1979, has yet to gain widespread support, but it remains a cornerstone of efforts to prevent the militarization of space. Enforcement will also be a major challenge. Even with robust treaties in place, ensuring compliance will require mechanisms for monitoring and accountability. This could involve the establishment of an international space court or the use of independent verification systems to detect violations. Without effective enforcement, the risk of an arms race in space remains high, threatening the stability of both Earth and the cosmos. Finally, the ethical implications of space militarization cannot be ignored. The development of space weapons raises questions about the morality of extending warfare beyond our planet. Should humanity, having barely begun to explore space, risk turning it into a new frontier for conflict? Or can we find ways to collaborate and ensure that space remains a realm of discovery and cooperation? As we look to the future, the decisions we make about space militarization will shape not only the trajectory of space exploration, but also the fate of our species. The stakes are high, but so too is the potential for progress. And as we consider these challenges, we move forward to explore another critical aspect of space law: the role of insurance and risk management in the era of extraterrestrial operations. As we navigate the complexities of space militarization, another pressing concern emerges: the role of insurance and risk management in the rapidly expanding realm of space activities. With the rise of commercial space travel, satellite launches, and even plans for extraterrestrial operations, the need for robust insurance frameworks has never been more critical. But how exactly will the insurance industry adapt to cover the unique risks of space? The first challenge lies in assessing the risks themselves. Space is an inherently unpredictable environment, with hazards ranging from micrometeoroid impacts to radiation exposure and equipment malfunctions. Unlike traditional insurance policies, which rely on decades of data to calculate risk, space insurance must grapple with limited historical information. This makes it difficult to predict the likelihood of accidents or failures, forcing insurers to rely on advanced simulations and expert analyses to set premiums. One area where space insurance is already making strides is in satellite launches. Companies like SpaceX and OneWeb are launching thousands of satellites to build global communication networks, and each launch carries significant financial and technical risks. Insurers have developed specialized policies to cover everything from launch failures to in-orbit malfunctions. However, as the number of satellites increases, so too does the risk of collisions and space debris, creating new challenges for the industry. Another emerging frontier is space tourism. As companies like Virgin Galactic and Blue Origin prepare to offer commercial space flights, insurers must account for the unique risks faced by passengers. These include the physical effects of microgravity, the potential for launch or re-entry failures, and even the psychological impact of space travel. Crafting policies that balance affordability with comprehensive coverage will be key to the industry's success. Extraterrestrial operations, such as lunar mining or Mars colonization, present even greater challenges. These activities involve not only technical risks but also legal and ethical uncertainties. For example, who is liable if a mining operation damages a historical lunar site? Or what happens if a Mars colony faces a catastrophic failure? Insurers will need to work closely with governments and private companies to develop policies that address these complex scenarios. The role of reinsurance will also become increasingly important. Reinsurers who provide insurance for insurance companies will play a critical role in spreading the financial risk of space activities across multiple entities. This will help ensure that even large-scale disasters, such as the loss of a major satellite constellation, do not overwhelm individual insurers. Finally, the rise of artificial intelligence and machine learning could revolutionize space insurance. These technologies can analyze vast amounts of data to identify patterns and predict risks with greater accuracy. For example, AI could help insurers assess the likelihood of satellite collisions or predict equipment failures before they occur. This would not only reduce costs but also improve safety across the industry. As we look to the future, the evolution of space insurance will be a key enabler of humanity's ambitions beyond Earth. By addressing the unique risks of space travel and operations, insurers can help ensure that the final frontier remains accessible and sustainable for generations to come. And with this foundation in place, we now turn to another fascinating aspect of space law: the preservation of historical sites in space and the legal frameworks needed to protect them. As we venture further into the cosmos, another layer of complexity emerges: the need to preserve humanity's extraterrestrial heritage. Space archaeology and heritage laws will play a crucial role in safeguarding historical sites beyond Earth, ensuring that our first steps into the universe are remembered and respected for generations to come. One of the most iconic examples is the Apollo landing sites on the Moon. These locations, where humans first set foot on another celestial body, hold immense historical and cultural significance. But as lunar exploration ramps up with plans for mining, tourism, and even settlements, these sites face the risk of damage or exploitation. Imagine a scenario where a lunar rover accidentally drives over the footprints left by Neil Armstrong and Buzz Aldrin, or a mining operation disrupts the Apollo 11 landing site. Without proper legal protections, such incidents could erase irreplaceable pieces of human history. To address this, international agreements will need to establish clear guidelines for the preservation of extraterrestrial heritage. This could involve designating certain areas as protected zones, similar to national parks on Earth, where human activity is strictly regulated. For example, the Apollo landing sites might be declared off-limits to commercial operations, with only scientific or educational missions allowed under specific conditions. Such measures would ensure that these sites remain intact for future generations to study and appreciate. But the challenge doesn't end with the Moon. As humanity expands its reach to Mars and beyond, we'll encounter new historical sites that require protection. For instance, the first human settlement on Mars could one day become a heritage site, just as ancient cities on Earth are preserved today. Legal frameworks will need to account for these future milestones, balancing the need for exploration and development with the imperative to protect our shared history. Another consideration is the role of private entities in space archaeology. Companies like SpaceX and Blue Origin are already leading the charge in space exploration, but their activities could inadvertently threaten historical sites. To prevent this, governments and international organizations will need to collaborate with private companies to establish best practices for preserving extraterrestrial heritage. This might include requiring companies to conduct archaeological surveys before beginning operations or mandating the use of technology that minimizes environmental impact. The enforcement of these laws will also be a critical issue. Unlike on Earth, where heritage sites are monitored by local authorities, space lacks a centralized governing body. This raises questions about who will oversee the protection of extraterrestrial sites and how violations will be addressed. One potential solution is the creation of an international space heritage organization tasked with monitoring and enforcing these laws. This body could work in tandem with existing space agencies and private companies to ensure compliance. Finally, there's the question of ownership: who has the right to claim and protect historical sites in space? Under current international law, celestial bodies like the Moon are considered the common heritage of mankind, meaning no single nation or entity can claim ownership. However, this principle may need to be revisited as we develop more specific heritage laws. For example, should the United States have special rights to protect the Apollo landing sites given their historical connection? Or should these sites be managed by an international consortium? These are complex questions that will require careful negotiation and collaboration. As we look to the stars, it's clear that space archaeology and heritage laws will be essential in preserving our extraterrestrial legacy. By protecting these sites, we honor the achievements of those who came before us and ensure that future generations can learn from and be inspired by humanity's journey into the cosmos. And with this foundation in place, we now turn to another exciting frontier: the legal implications of harvesting solar energy in space and transmitting it to Earth. Now, let's shift our focus to a groundbreaking concept that could revolutionize how we power our planet: space-based energy. Imagine harnessing the sun's energy directly from space, where sunlight is constant and unobstructed by Earth's atmosphere. This idea, once the stuff of science fiction, is now becoming a tangible possibility, but it comes with a host of legal challenges that must be addressed. One of the most significant hurdles is determining who owns the energy harvested in space. Under current international law, celestial bodies and their resources are considered the common heritage of mankind, meaning no single nation or entity can claim exclusive ownership. However, this principle becomes murky when applied to space-based energy. If a company or nation builds a solar power station in orbit, do they have the right to claim the energy it produces? Or should the benefits be shared globally? These questions will require careful negotiation to ensure fairness and prevent conflicts. Another challenge lies in the transmission of energy from space to Earth. Technologies like microwave or laser beams could be used to send energy back to our planet, but this raises concerns about safety and regulation. For instance, what happens if a beam accidentally veers off course and damages property or harms people? Legal frameworks will need to establish strict safety standards and liability rules to address such risks. Additionally, international agreements may be required to regulate the use of orbital slots for energy transmission, ensuring that one nation's energy project doesn't interfere with another's satellites or communication systems. The distribution of space-based energy also presents complex legal questions. If energy harvested in space is transmitted to Earth, how will it be allocated among nations? Will wealthier countries have greater access, or will mechanisms be put in place to ensure equitable distribution? This issue ties into broader discussions about global energy justice and the need to address disparities in access to resources. Legal frameworks could play a key role in creating systems that prioritize fairness and sustainability. Moreover, the environmental impact of space-based energy projects must be considered. While solar energy is clean and renewable, the construction and operation of space-based power stations could contribute to space debris or disrupt the delicate balance of Earth's orbit. Laws will need to mandate environmentally responsible practices, such as minimizing debris and ensuring that decommissioned satellites are safely removed from orbit. This will require collaboration between governments, private companies, and international organizations to establish best practices and enforce compliance. As we explore the potential of space-based energy, it's clear that the legal landscape will need to evolve alongside technological advancements. By addressing issues of ownership, safety, distribution, and environmental impact, we can create a framework that supports innovation while ensuring that the benefits of space-based energy are shared equitably. With these challenges in mind, we now turn to another critical aspect of space law: the regulation of data collected in space and the protection of privacy in an increasingly connected universe. As we venture further into the cosmos, another pressing issue emerges: the regulation of data collected in space and the protection of privacy. Satellites orbiting Earth capture vast amounts of information, from high-resolution images of our planet to data about weather patterns, urban development, and even individual activities. While this data has immense potential for scientific research, disaster management, and economic growth, it also raises significant concerns about privacy and misuse. How do we ensure that the benefits of space-based data collection don't come at the cost of personal privacy? One of the first challenges is defining what constitutes private data in the context of space. Unlike traditional privacy laws that focus on personal information collected on Earth, space-based data often involves imagery and signals that can indirectly reveal sensitive details. For example, satellite images might capture private property, military installations, or even individuals going about their daily lives. Legal frameworks will need to establish clear boundaries on what can be collected, stored, and shared. balancing the need for transparency with the right to privacy. Another critical issue is the ownership and control of space-based data. Currently, many satellites are operated by private companies, raising questions about who has the right to access and use the data they collect. Should governments have oversight over this information to prevent misuse, or should companies retain full control? This debate becomes even more complex when considering international collaborations, where data collected by one nation's satellites might be shared with others. Legal agreements will need to address these dynamics, ensuring that data is used responsibly and ethically. The potential for misuse of space-based data is another area of concern. High-resolution satellite imagery could be exploited for surveillance, corporate espionage, or even cyber attacks. To prevent such scenarios, laws will need to establish strict guidelines on how data can be used and by whom. This might include requiring companies to obtain consent before collecting certain types of data, or implementing encryption and anonymization techniques to protect sensitive information. Additionally, international cooperation will be essential to create unified standards that prevent bad actors from exploiting gaps in regulations. Transparency and accountability will also play a key role in protecting space data privacy. Governments and companies operating satellites should be required to disclose what data they collect, how it is used, and who has access to it. This transparency can help build public trust and ensure that data collection practices align with societal values. At the same time, mechanisms for accountability, such as independent oversight bodies, will be necessary to enforce compliance and address any breaches of privacy. Finally, as space-based data collection becomes more advanced, we must consider the long-term implications for privacy. Emerging technologies such as artificial intelligence and machine learning could enable the analysis of vast datasets in ways that were previously unimaginable. Legal frameworks will need to anticipate these advancements, creating flexible regulations that can adapt to new challenges while safeguarding privacy rights. With these considerations in mind, it's clear that the regulation of space data privacy will be a complex but essential aspect of space law. By addressing issues of ownership, misuse, transparency, and accountability, we can create a framework that protects individual privacy while harnessing the immense potential of space-based data. As we continue to explore the cosmos, let's turn our attention to another critical area: the development of labor laws for those working in space, ensuring safety and fairness in this new frontier. As we shift our focus from the complexities of space data privacy, another critical frontier emerges: the rights and protections of those who work in space. The development of space labor laws will be essential as humanity expands its presence beyond Earth, ensuring that astronauts, space station workers, and future extraterrestrial employees are treated fairly and safely in this uncharted environment. One of the first challenges will be defining what constitutes fair working conditions in space. Unlike Earth, where labor laws are shaped by centuries of experience, space presents unique hazards such as microgravity, radiation exposure, and isolation. Legal frameworks will need to establish clear safety standards to protect workers from these risks. For example, regulations might mandate limits on the amount of time spent in microgravity to prevent long-term health issues or require advanced shielding to minimize radiation exposure. These measures will be crucial to ensuring that space workers can perform their duties without compromising their well-being. Compensation is another area that will require careful consideration. Working in space is inherently risky and demanding, raising questions about how to fairly compensate those who take on these challenges. Should space workers receive hazard pay, similar to how certain professions on Earth are compensated for dangerous conditions? Additionally, how will wages be determined for jobs that have no direct Earth-based equivalent, such as asteroid miners or lunar construction workers? Legal frameworks will need to address these questions, balancing the need to attract skilled workers with the economic realities of space operations. Another key issue is the jurisdiction of space labor laws. Currently, the Outer Space Treaty states that space is the province of all mankind, but it does not provide clear guidelines on how labor laws should be enforced in extraterrestrial environments. Will workers be protected by the laws of their home country, or will new international agreements be needed to create a unified set of standards? This question becomes even more complex when considering multinational space stations or colonies, where workers from different nations may be subject to conflicting regulations. Legal experts will need to navigate these complexities to create a fair and enforceable system. The rights of space workers will also extend beyond safety and compensation. Issues such as work hours, rest periods, and mental health support will need to be addressed. For instance, how do you regulate a workday when the concept of a day varies depending on the celestial body? On the Moon, a day lasts about 28 Earth days, while on Mars, it's slightly longer than 24 hours. Legal frameworks will need to adapt to these unique conditions, ensuring that workers have adequate time for rest and recreation despite the challenges of their environment. Finally, as space colonization becomes a reality, we must consider the rights of future generations born and raised in space. Will they be subject to the same labor laws as Earth-based workers, or will new standards be developed to reflect their unique circumstances? This raises profound questions about identity, citizenship, and the long-term evolution of human society in space. The development of space labor laws will be a cornerstone of humanity's expansion into the cosmos. By addressing issues of safety, compensation, jurisdiction, and workers' rights, we can create a framework that ensures fairness and dignity for those who venture beyond our planet. As we continue to explore the legal challenges of space, let's turn our attention to another fascinating topic: the complexities of space inheritance and estate laws, and how they will shape the future of extraterrestrial assets. As we venture further into the cosmos, the question of what happens to our possessions beyond Earth becomes increasingly relevant. Space inheritance and estate laws will play a pivotal role in shaping how humanity manages extraterrestrial assets, from lunar real estate to asteroid mining claims. Unlike traditional inheritance laws on Earth, which are well established and rooted in centuries of legal precedent, space inheritance will require entirely new frameworks to address the unique challenges of ownership in the final frontier. One of the first hurdles will be determining jurisdiction. If someone owns property on the Moon or Mars, which legal system governs the transfer of those assets after their death? Currently, the Outer Space Treaty prohibits nations from claiming sovereignty over celestial bodies, but it does not address private ownership or inheritance. This raises complex questions. Will space assets fall under the jurisdiction of the deceased's home country, or will an international body oversee extraterrestrial inheritance? Legal experts will need to craft agreements that balance national laws with the global nature of space exploration. Another challenge lies in the valuation of space assets. How do you appraise a piece of lunar land or a stake in an asteroid mining operation? Unlike Earth-based properties, which have established markets and valuation methods, space assets are speculative, and their worth may fluctuate dramatically based on technological advancements and resource discoveries. This uncertainty could lead to disputes among heirs, requiring courts to develop new methods for assessing the value of extraterrestrial properties. Extraterrestrial wills will also need to account for the unique conditions of space. For example, what happens if a will is created on Mars where the concept of a day differs from Earth's 24-hour cycle? Will the document be legally binding if it's signed under Martian time? Additionally, how do you ensure the authenticity of a will created in a remote space colony where access to legal professionals and notaries may be limited? These questions highlight the need for innovative legal solutions that adapt to the realities of life beyond Earth. The issue of inheritance becomes even more complex when considering future generations born and raised in space. Will they have the same right to inherit Earth-based assets as those born on our home planet? Conversely, how will Earth-based heirs claim ownership of space assets if they have never set foot on the Moon or Mars? These scenarios will require laws that bridge the gap between terrestrial and extraterrestrial societies, ensuring fairness and clarity for all parties involved. Finally, space inheritance laws will need to address the preservation of historical and cultural assets. For instance, if a family owns a plot of land near the Apollo 11 landing site, how do you ensure that this piece of history is protected for future generations? Legal frameworks will need to balance private ownership with the collective interest in preserving humanity's extraterrestrial heritage. As we look to the stars, the development of space inheritance and estate laws will be essential to ensuring that humanity's expansion into the cosmos is both orderly and equitable. By addressing these challenges, we can create a legal system that respects the rights of individuals while fostering cooperation and shared progress in space. Now, let's turn our attention to another critical aspect of space law: the evolution of international treaties and how they will shape the future of space diplomacy. As we navigate the complexities of space inheritance, it's clear that the legal frameworks governing our extraterrestrial future will rely heavily on international cooperation. This brings us to the next frontier of space law: the evolution of space diplomacy and treaties. The Outer Space Treaty, signed in 1967, laid the foundation for peaceful exploration and use of outer space. However, as humanity's ambitions grow, so too must the agreements that guide our actions beyond Earth. One of the most pressing challenges is updating the Outer Space Treaty to reflect the realities of modern space exploration. While the treaty prohibits nations from claiming sovereignty over celestial bodies, it does not explicitly address the activities of private companies or the exploitation of space resources. This ambiguity has led to debates over whether current laws are sufficient to regulate activities like asteroid mining or lunar settlements. To address these gaps, nations will need to come together to draft new agreements or amend existing ones, ensuring that space remains a shared resource for all humanity. Another key area of focus will be ensuring equitable access to space. As more countries and private entities enter the space race, there is a risk that wealthier nations or corporations could dominate access to critical resources or strategic locations. To prevent this, future treaties may include provisions that promote fair distribution of space resources and opportunities. For example, an international body could be established to oversee the allocation of lunar mining rights or the placement of satellites in orbit, ensuring that all nations, regardless of their economic status, have a voice in shaping the future of space. Space diplomacy will also need to address the growing issue of space debris. With thousands of satellites and other objects orbiting Earth, the risk of collisions and the creation of more debris is a serious concern. Future treaties may include stricter regulations on satellite launches and end-of-life disposal, as well as mechanisms for international cooperation in tracking and mitigating space debris. This will require nations to set aside their differences and work together to protect the space environment for future generations. The role of emerging technologies will also shape the evolution of space treaties. Advances in artificial intelligence, robotics, and space-based manufacturing will create new opportunities and challenges that current laws are not equipped to handle. For instance, how do you regulate the use of autonomous spacecraft or the construction of large-scale structures in orbit? These questions will require innovative legal solutions that balance the need for progress with the principles of safety and fairness. Finally, space diplomacy will play a crucial role in preventing conflict beyond Earth. As nations and companies compete for access to space resources, there is a risk of disputes escalating into full-blown conflicts. To mitigate this, future treaties may include provisions for conflict resolution and the peaceful settlement of disputes. This could involve the creation of a space court or arbitration body, where nations and private entities can resolve their differences without resorting to violence. The evolution of space diplomacy and treaties will be essential to ensuring that humanity's expansion into the cosmos is guided by principles of cooperation, fairness, and sustainability. By addressing these challenges, we can create a legal framework that not only protects our shared interests in space, but also fosters a spirit of collaboration that transcends borders. Now, let's explore how space-based agriculture and the legal rights surrounding it will shape our future among the stars. As we turn our attention to the future of space-based agriculture, it's fascinating to consider how the act of growing food beyond Earth will reshape our legal frameworks. Imagine a world where crops are cultivated on the Moon, Mars, or even in orbiting space stations. While this vision holds incredible promise for sustaining long-term human presence in space, it also raises complex questions about ownership, regulation, and the ethical use of genetically modified organisms. One of the first legal challenges will be determining who owns the crops grown in space. Under current international space law, no nation can claim sovereignty over celestial bodies, but what about the resources produced there? If a private company grows wheat on the Moon, do they own the harvest, or does it belong to humanity as a whole? These questions will require new agreements that clarify ownership rights while balancing the interests of private entities and the global community. Another critical issue is the regulation of genetically modified organisms, or GMO, in space. On Earth, GMOs are a contentious topic, with debates over their safety, environmental impact, and ethical implications. In space, the stakes are even higher. Modifying crops to thrive in low gravity, high radiation, or limited water conditions could be essential for survival. However, this raises concerns about unintended consequences, such as cross-contamination with native environments on Mars or the Moon. Future space laws will need to establish clear guidelines for the development, testing, and use of GMOs in extraterrestrial agriculture, ensuring both safety and innovation. The legal framework for space-based agriculture will also need to address resource allocation. Water, nutrients, and energy are scarce in space, and their use for farming could conflict with other priorities, such as life support systems or scientific research. Who gets to decide how these resources are distributed? An international body may need to oversee the fair allocation of resources, ensuring that agricultural activities do not compromise the sustainability of space habitats or the rights of other stakeholders. Intellectual property rights will also come into play. Companies investing in space agriculture may develop proprietary technologies or crop varieties designed for extraterrestrial environments. How will these innovations be protected, and how can we ensure that the benefits of such advancements are shared equitably? Future treaties may need to include provisions that balance the protection of intellectual property with the need for open collaboration and access to essential technologies. Finally, space-based agriculture will require international cooperation to address cross-border challenges. For example, if a nation or company grows food on the Moon, how will they ensure that their activities do not interfere with those of others? Legal frameworks will need to establish clear boundaries and protocols for resolving disputes, fostering a spirit of collaboration rather than competition. As we look to the stars, the legal implications of space-based agriculture remind us that our journey into the cosmos is not just about exploration, but also about creating sustainable systems that benefit all of humanity. By addressing these challenges, we can ensure that the food we grow in space nourishes not only our bodies, but also our shared vision of a cooperative and equitable future. Now, let's shift our focus to the potential for space piracy and the legal measures needed to combat unauthorized activities in orbit or on celestial bodies. As we venture further into the cosmos, the concept of space piracy emerges as a pressing concern. Picture this: rogue actors intercepting valuable cargo shipments between Earth and the Moon, or even hijacking satellites for ransom. While it may sound like the plot of a science fiction movie, the reality is that as space becomes more accessible, the risk of unauthorized activities in orbit or on celestial bodies grows. This brings us to the critical need for robust legal measures to prevent and address space piracy. One of the first challenges in tackling space piracy is defining what it actually entails. Unlike piracy on Earth, which typically involves ships and coastal regions, space piracy could take many forms. It might include the theft of resources mined from asteroids, the sabotage of space stations, or the unauthorized use of communication satellites. Establishing a clear legal definition of space piracy will be essential for creating enforceable laws and international agreements. Enforcement presents another significant hurdle. Space is vast, and monitoring every corner of it for illegal activities is nearly impossible with current technology. This raises questions about jurisdiction and responsibility. If a pirate operation is launched from one country but targets assets owned by another, who has the authority to intervene, future space laws will need to outline clear protocols for identifying, tracking, and apprehending space pirates, as well as determining which legal systems apply in such cases. International cooperation will be key to combating space piracy effectively. Just as nations collaborate to address piracy on Earth through organizations like the International Maritime Organization, a similar global body may be needed for space. This organization could oversee the development of shared surveillance systems, coordinate responses to piracy incidents, and establish standardized penalties for offenders. By working together, nations can create a unified front against space piracy, ensuring that the final frontier remains a place of exploration and innovation, not lawlessness. Another important consideration is the role of private companies in preventing space piracy. As commercial activities in space increase, companies will have a vested interest in protecting their assets. This could lead to the development of private security measures, such as satellite defense systems or encrypted communication networks. However, these efforts must be carefully regulated to avoid escalating tensions or creating new risks. Future space laws will need to strike a balance between empowering private entities to protect their interests and ensuring that their actions do not undermine global security. Finally, the legal framework for addressing space piracy must also consider the ethical implications. For example, how should we handle cases where individuals or groups engage in piracy out of necessity, such as resource scarcity or political oppression? While piracy cannot be condoned, understanding the underlying causes may help shape more effective and humane solutions. This could involve creating pathways for equitable access to space resources or addressing systemic issues that drive individuals to such extremes. As humanity expands its presence in space, the threat of piracy reminds us that the cosmos is not immune to the challenges we face on Earth. By proactively developing comprehensive legal measures, we can safeguard the integrity of space activities and ensure that the benefits of exploration are shared by all. Now, let's turn our attention to the evolving laws that will govern space-based communication networks and the challenges of bandwidth allocation and interference. As we navigate the complexities of space law, another critical area emerges: the regulation of space-based communication networks. Imagine a future where satellites orbiting Earth form the backbone of global internet access, enabling seamless connectivity even in the most remote regions. While this vision holds immense promise, it also raises significant legal challenges that must be addressed to ensure fair and efficient use of space for communication. One of the most pressing issues is bandwidth allocation. With an increasing number of satellites being launched into orbit, the competition for limited radio frequencies and orbital slots is intensifying. Without clear regulations, this could lead to interference between communication networks, disrupting services and creating conflicts between nations and private companies. Future space laws will need to establish frameworks for allocating bandwidth fairly, ensuring that all stakeholders have access to the resources they need while minimizing the risk of interference. Another challenge is the prevention of signal jamming and cyber attacks on space-based communication systems. As these networks become more integral to global infrastructure, they also become more attractive targets for malicious actors. Laws will need to address not only the technical aspects of securing these systems, but also the legal consequences for those who attempt to disrupt them. This could involve international agreements to criminalize such activities and establish protocols for responding to attacks. The role of private companies in space-based communication also raises important legal questions. Companies like SpaceX and OneWeb are already deploying constellations of satellites to provide global internet coverage. While these initiatives have the potential to bridge the digital divide, they also highlight the need for regulations to prevent monopolies and ensure equitable access. Future laws may require companies to share bandwidth or contribute to a global fund that supports universal connectivity. International cooperation will be essential in shaping these regulations. Just as the International Telecommunication Union coordinates the use of radio frequencies on Earth, a similar body may be needed to oversee space-based communication. This organization could facilitate negotiations between nations, set standards for satellite deployment, and resolve disputes over bandwidth allocation. By fostering collaboration, we can create a legal framework that supports innovation while protecting the interests of all stakeholders. Finally, space-based communication laws must also consider the long-term sustainability of Earth's orbit. The proliferation of satellites increases the risk of space debris, which can interfere with communication networks and pose a hazard to other spacecraft. Regulations will need to address not only the deployment of satellites but also their end-of-life disposal, ensuring that they are deorbited or moved to a graveyard orbit once they are no longer functional. As we look to the future, the regulation of space-based communication networks will play a crucial role in shaping how humanity connects and collaborates. By addressing issues like bandwidth allocation, interference, and sustainability, we can create a legal framework that supports the growth of these networks while ensuring they remain accessible and secure for all. Now, let's explore the legal frameworks that will govern healthcare in space and the unique challenges of providing medical services beyond Earth. As we venture further into the cosmos, the need for robust legal frameworks to govern healthcare in space becomes increasingly apparent. Providing medical services beyond Earth presents unique challenges that demand innovative solutions and clear regulations. In the microgravity environment of space, the human body undergoes significant changes, from bone density loss to fluid redistribution, which can complicate diagnosis and treatment. Future space laws will need to address these physiological challenges while ensuring the safety and well-being of astronauts and space travelers. One of the key areas of focus will be the regulation of medical experiments conducted in space. Research in microgravity offers unprecedented opportunities to study diseases, develop new treatments, and test medical technologies. However, these experiments must be carefully regulated to protect participants and ensure ethical standards are upheld. Laws will need to establish guidelines for informed consent, data privacy, and the ethical use of human subjects in space-based research. This will require collaboration between space agencies, medical institutions, and legal experts to create a framework that balances scientific progress with ethical responsibility. Another critical aspect of space healthcare is the development of standardized medical protocols for treating injuries and illnesses in extraterrestrial environments. Unlike on Earth, where emergency medical services are readily available, space missions may be days or even months away from the nearest hospital. future regulations will need to outline the minimum medical equipment and supplies required for different types of missions, as well as the training and qualifications of medical personnel on board. These protocols will ensure that astronauts have access to timely and effective care, even in the most remote locations. The legal framework for space healthcare must also address the unique challenges of telemedicine. In space, real-time communication with medical experts on Earth may be limited by distance and signal delays. Laws will need to define the responsibilities of telemedicine providers and establish standards for remote diagnosis and treatment. This could include guidelines for the use of artificial intelligence and autonomous medical systems to assist in decision-making when direct communication is not possible. By leveraging technology, we can enhance the quality of healthcare in space while minimizing risks to patients. Additionally, the issue of liability in space healthcare will require careful consideration. In the event of a medical error or malpractice, determining responsibility can be complex, especially when multiple jurisdictions are involved. Future space laws will need to clarify the legal obligations of healthcare providers, space agencies, and private companies, ensuring that victims have access to fair compensation. This could involve the creation of specialized space courts or arbitration systems to handle disputes related to medical care in extraterrestrial environments. Finally, the long-term health effects of space travel must be addressed through comprehensive legal frameworks. Prolonged exposure to microgravity, radiation, and isolation can have lasting impacts on physical and mental health. Regulations will need to mandate regular health monitoring and provide guidelines for post-mission care and rehabilitation. By prioritizing the health and well-being of space travelers, we can ensure that humanity's journey into the cosmos is not only successful but also sustainable. As we look to the future, the development of space health and medical regulations will play a crucial role in enabling safe and effective healthcare beyond Earth. By addressing the unique challenges of space medicine, we can create a legal framework that supports the health and well-being of all who venture into the final frontier. Now, let's turn our attention to the legal measures that will ensure equitable access to space-based educational opportunities, such as zero-gravity research programs. As we shift our focus to the realm of education beyond Earth, it's clear that space-based learning opportunities will play a pivotal role in shaping the future of science and innovation. Zero-gravity research programs, for instance, offer students and researchers a chance to conduct experiments in environments that simply cannot be replicated on Earth. However, ensuring equitable access to these programs will require thoughtful legal frameworks that prioritize fairness and inclusivity. One of the first challenges will be defining who has the right to participate in space-based educational initiatives. With limited resources and high costs associated with space travel, laws will need to establish clear criteria for eligibility. This could include provisions for underrepresented groups, ensuring that students from diverse backgrounds have the opportunity to engage in groundbreaking research. By creating pathways for participation, we can foster a more inclusive space community that reflects the diversity of humanity. Another key consideration is the funding and sponsorship of space education programs. Governments, private companies, and international organizations will need to collaborate to make these opportunities financially accessible. Legal frameworks could mandate that a portion of space-related revenues, such as those from asteroid mining or satellite services, be allocated to educational initiatives. This would not only support the next generation of scientists and engineers, but also ensure that the benefits of space exploration are shared more broadly. Intellectual property rights will also come into play when it comes to space-based education. Students and researchers conducting experiments in space may develop new technologies or make groundbreaking discoveries. Laws will need to clarify who owns the rights to these innovations, whether it's the individual, the institution funding the research, or a broader consortium. Establishing clear guidelines will encourage innovation while protecting the interests of all parties involved. Additionally, the legal framework must address the safety and ethical considerations of sending students and educators into space. Regulations will need to outline the minimum safety standards for educational missions, including the training and qualifications required for participants. Ethical guidelines will also be essential to ensure that experiments conducted by students do not pose risks to themselves, others, or the space environment. By prioritizing safety and ethics, we can create a sustainable model for space-based education. Finally, international cooperation will be crucial in ensuring equitable access to space education. Space is a shared resource, and no single nation should monopolize its educational opportunities. Treaties and agreements will need to be established to promote collaboration between countries, allowing students from around the world to participate in space research programs. This global approach will not only enhance the quality of education, but also strengthen diplomatic ties and foster a sense of unity in our shared exploration of the cosmos. As we look ahead, the legal measures governing space-based education will be instrumental in democratizing access to the final frontier. By creating fair, inclusive, and collaborative frameworks, we can inspire the next generation of explorers and ensure that the benefits of space exploration are accessible to all. Now, let's explore how laws will protect and promote art and culture created in space, ensuring that humanity's creative spirit thrives beyond Earth. As we venture into the realm of creativity beyond our planet, the legal framework surrounding space art and cultural preservation will become increasingly vital. Imagine a future where artists paint in zero gravity, musicians compose symphonies inspired by the cosmos, and writers craft stories from the vantage point of a Martian colony. These works of art will not only reflect humanity's ingenuity, but also serve as a testament to our shared cultural heritage in space. However, protecting and promoting these creations will require thoughtful legal measures that balance innovation with preservation. One of the first challenges will be establishing copyright laws for art created in space. Currently, copyright protections are tied to terrestrial jurisdictions, but space operates under international treaties like the Outer Space Treaty. This raises questions about who owns the rights to a painting created on the Moon or a song composed aboard the International Space Station. Will it be the artist, the organization funding the mission, or the nation under whose flag the spacecraft operates? Legal frameworks will need to clarify these ownership rights to encourage artistic expression while ensuring creators are fairly compensated. Cultural heritage laws will also play a crucial role in preserving space art. Just as we protect historical sites on Earth, we must safeguard significant artistic and cultural landmarks in space. For example, the first sculpture placed on the Moon or the inaugural performance in a Martian theater could hold immense cultural value. Laws will need to designate these creations as protected heritage sites, preventing their destruction or exploitation. This will ensure that future generations can appreciate the artistic milestones of humanity's journey into space. Another consideration is the promotion of space art to inspire global audiences. Legal frameworks could mandate that a portion of space-related revenues be allocated to funding artistic projects in space. This could include grants for artists, sponsorships for cultural events, or even the creation of space-based art galleries. By investing in space art, we can foster a deeper connection between humanity and the cosmos, making space exploration more relatable and inspiring for people around the world. Ethical guidelines will also be essential to ensure that space art respects the principles of inclusivity and diversity. Laws could require that artistic opportunities in space be accessible to individuals from all backgrounds, regardless of nationality, gender, or socioeconomic status. This would not only enrich the cultural landscape of space, but also reflect the universal nature of human creativity. By prioritizing fairness, we can ensure that space art represents the full spectrum of human experience. Finally, international collaboration will be key to preserving and promoting space art. Space is a shared resource, and no single nation should dominate its cultural expression. Treaties and agreements will need to be established to encourage cooperation between countries, allowing artists from around the world to contribute to the cultural heritage of space. This global approach will not only enhance the quality of space art, but also strengthen the bonds between nations as we collectively explore the cosmos. As we look to the future, the legal measures governing space art and cultural preservation will be instrumental in shaping humanity's creative legacy beyond Earth. By protecting artistic expression, promoting inclusivity, and fostering international collaboration, we can ensure that the beauty of human creativity continues to thrive in the stars. Now, let's turn our attention to the ethical and legal challenges of ensuring human rights in space, where freedom, equality, and dignity must remain at the forefront of our cosmic endeavors. As we shift our focus from the artistic and cultural dimensions of space exploration, we now delve into a critical aspect of humanity's future beyond Earth: the ethical and legal challenges of ensuring human rights in space. The principles of freedom, equality, and dignity, which form the foundation of human rights on Earth, must extend seamlessly into the cosmos as we establish permanent settlements and expand our presence among the stars. One of the most pressing ethical questions is how to guarantee basic freedoms in extraterrestrial environments. On Earth, freedoms such as speech, movement, and assembly are protected by laws and societal norms. However, in the confined and high-stakes settings of space habitats or colonies, these freedoms may face unique constraints. For instance, the need for strict safety protocols in space could limit personal movement or require adherence to rigid schedules. Legal frameworks will need to strike a delicate balance between ensuring safety and preserving individual liberties, ensuring that spacefarers do not feel unduly restricted in their daily lives. Equality is another cornerstone of human rights that must be upheld in space. As space exploration becomes more accessible, it is essential to ensure that opportunities are available to individuals from all walks of life, regardless of nationality, gender, or socioeconomic status. This includes equitable access to space travel, employment in extraterrestrial industries, and participation in decision-making processes that affect space communities. Legal measures will need to address potential disparities, such as the risk of wealthier nations or corporations dominating space resources, and ensure that the benefits of space exploration are shared globally. Dignity, too, must be a guiding principle in the development of space laws. This means respecting the intrinsic worth of every individual, regardless of their role or background. For example, astronauts, scientists, and even space tourists should all be treated with the same level of respect and care. Legal frameworks will need to address issues such as fair working conditions, access to healthcare, and protection from exploitation or discrimination in space environments. Ensuring dignity also involves creating spaces where individuals can thrive emotionally and psychologically, recognizing the unique challenges of living in isolation or under extreme conditions. Another ethical challenge is the potential for conflicts between different cultural or legal systems in space. As nations and private entities establish colonies or outposts, questions may arise about which laws apply in specific situations. For instance, if a dispute occurs between individuals from different countries on a lunar base, whose legal system should govern the resolution, international treaties will need to establish clear guidelines for jurisdiction and conflict resolution, ensuring that all parties are treated fairly and that human rights are upheld universally. The concept of human rights in space also extends to future generations. As we lay the groundwork for long-term habitation, we must consider the rights of those who will inherit these extraterrestrial communities. This includes ensuring access to education, healthcare, and opportunities for personal growth, as well as protecting the environment of celestial bodies for future exploration and use. Legal frameworks will need to be forward-thinking, addressing not only the needs of current spacefarers but also the rights and well-being of those who will follow. Finally, the enforcement of human rights in space will require robust international cooperation. Space is a shared domain, and no single nation or entity should have unchecked authority over its governance. Treaties and agreements will need to be established to create a unified approach to human rights in space, fostering collaboration and mutual respect among nations. This global effort will not only protect the rights of individuals but also strengthen the bonds of humanity as we collectively explore and inhabit the cosmos. As we look to the future, the ethical and legal challenges of ensuring human rights in space will be central to our success as a spacefaring civilization. By prioritizing freedom, equality, and dignity, we can create a future where all individuals, regardless of their location in the universe, are treated with the respect and fairness they deserve. Now, let's explore how artificial intelligence will shape the enforcement and interpretation of space laws, paving the way for a new era of legal innovation in the cosmos. As we venture further into the complexities of space law, one of the most transformative forces on the horizon is artificial intelligence. The role of artificial intelligence in shaping the enforcement and interpretation of space laws cannot be overstated. With the vastness of space and the increasing complexity of extraterrestrial activities, traditional legal systems may struggle to keep pace. Artificial intelligence offers a solution by providing tools for real-time monitoring, analysis, and decision-making in space-related legal matters. One of the most immediate applications of artificial intelligence in space law is in the realm of space traffic management. As the number of satellites, spacecraft, and debris in orbit continues to grow, the risk of collisions and conflicts increases. Artificial intelligence can be used to predict and prevent these incidents by analyzing vast amounts of data from sensors and satellites. This not only enhances safety, but also helps in enforcing regulations related to space traffic, ensuring that all entities adhere to agreed-upon guidelines. Artificial intelligence also has the potential to revolutionize the way space laws are interpreted and applied. Legal disputes in space may involve complex technical details, such as the ownership of resources extracted from asteroids or the jurisdiction over a lunar base. Artificial intelligence systems can assist legal professionals by analyzing relevant treaties, case law, and technical data to provide informed recommendations. This could lead to more consistent and fair outcomes, reducing the likelihood of prolonged legal battles. Another exciting prospect is the development of autonomous legal systems powered by artificial intelligence. These systems could operate in real time, making decisions based on pre-programmed legal frameworks and real-time data. For example, an autonomous legal system on a Mars colony could handle disputes between residents, allocate resources, and enforce local laws without the need for human intervention. This would be particularly valuable in remote or isolated environments where access to human legal experts is limited. However, the integration of artificial intelligence into space law also raises important ethical and practical questions. Who is responsible if an artificial intelligence system makes an incorrect or biased decision? How do we ensure that these systems are transparent and accountable? Legal frameworks will need to address these challenges, establishing guidelines for the development, deployment, and oversight of artificial intelligence in space law. Moreover, artificial intelligence could play a crucial role in ensuring compliance with international space treaties. By monitoring activities in space and analyzing data, artificial intelligence systems can help identify violations of treaties, such as the unauthorized use of space resources or the deployment of prohibited technologies. This would enhance the ability of the international community to enforce space laws and maintain order in the cosmos. As we look to the future, the collaboration between artificial intelligence and space law will be essential for creating a fair and efficient legal framework for extraterrestrial activities. By leveraging the capabilities of artificial intelligence, we can address the unique challenges of space law, ensuring that humanity's expansion into the cosmos is guided by principles of justice, equity, and sustainability. Now, let's explore how space law could intersect with another pressing global issue: climate change and the potential for space-based solutions to address environmental challenges on Earth. As we turn our attention to the intersection of space law and climate change, it becomes clear that the cosmos holds more than just the promise of exploration. It may also offer solutions to one of humanity's most pressing challenges. Space law has the potential to play a pivotal role in addressing climate change, particularly through the regulation of space-based technologies designed to monitor and mitigate environmental issues on Earth. One of the most promising applications is the use of satellites to monitor Earth's climate systems. Satellites equipped with advanced sensors can track changes in temperature, sea levels, deforestation, and greenhouse gas emissions with unparalleled precision. This data is invaluable for scientists and policymakers working to combat climate change. However, the collection and sharing of this information raise important legal questions. Who owns the data collected by these satellites? How can we ensure that it is used ethically and equitably? Space law will need to establish clear guidelines for data ownership, access, and usage to prevent misuse and ensure that all nations benefit from this critical information. Another area where space law could make a significant impact is in the regulation of space-based geoengineering projects. Geoengineering refers to large-scale interventions in Earth's natural systems to counteract climate change. One proposed method involves deploying reflective particles in the atmosphere to reduce the amount of sunlight reaching the Earth's surface, effectively cooling the planet. While this approach could help mitigate global warming, it also carries significant risks such as unintended environmental consequences and geopolitical tensions. Space law will need to address these risks by creating frameworks for the responsible development and deployment of geoengineering technologies. This includes establishing international agreements to govern their use, ensuring transparency, and requiring thorough risk assessments before any project is approved. Space law could also play a role in regulating the extraction and use of space resources to support climate change mitigation efforts on Earth. For example, rare metals and minerals found on asteroids could be used to develop advanced renewable energy technologies, such as more efficient solar panels or batteries. However, the extraction and transportation of these resources must be carefully regulated to avoid environmental harm and ensure fair distribution. Legal frameworks will need to balance the economic potential of space mining with the need to protect Earth's environment and promote sustainable development. Additionally, space law can help address the growing issue of space debris, which poses a threat not only to space operations but also to Earth's environment. Collisions between satellites and debris can create more debris, leading to a cascade effect known as the Kessler syndrome. This could render certain orbits unusable, disrupting critical climate monitoring systems. Space law must establish stricter regulations for debris mitigation, including requirements for satellite disposal and the development of technologies to remove existing debris. By addressing this issue, space law can help preserve the integrity of Earth's orbital environment, ensuring that it remains a valuable tool for climate monitoring and mitigation. As we look to the future, the collaboration between space law and climate science will be essential for developing innovative solutions to environmental challenges. By creating robust legal frameworks, we can harness the potential of space-based technologies to protect our planet while ensuring that these efforts are guided by principles of equity, sustainability, and international cooperation. Now, let's shift our focus to another critical aspect of space law: the establishment of specialized space courts to handle disputes related to extraterrestrial activities and ownership rights. As we venture further into the realm of space law, another groundbreaking development on the horizon is the establishment of specialized space courts. These courts will be designed to address the unique legal challenges that arise from activities beyond Earth, ensuring that disputes over extraterrestrial ownership rights and operations are resolved fairly and efficiently. The need for such courts becomes evident as humanity's presence in space expands, with nations and private companies vying for resources on the Moon, Mars, and asteroids. Conflicts over property rights, resource extraction, and territorial claims are inevitable. Traditional legal systems on Earth are ill-equipped to handle these disputes, as they operate within the confines of terrestrial laws and jurisdictions. Space courts, on the other hand, would be tailored to the complexities of space activities, offering a neutral and specialized forum for resolving conflicts. One of the key challenges in creating space courts is defining their jurisdiction. Unlike Earth, where borders and territories are clearly marked, space is a vast, borderless expanse. Determining which court has authority over a dispute involving a lunar mining operation or a Mars colony will require innovative legal frameworks. These frameworks will likely involve international agreements that outline the scope of space courts' authority and establish clear rules for which cases they can hear. Another critical aspect of space courts is their ability to adapt to the rapidly evolving nature of space exploration. As new technologies emerge and our understanding of space deepens, the legal landscape will need to keep pace. Space courts will play a vital role in interpreting and applying space law in ways that reflect the realities of extraterrestrial activities. This includes addressing issues such as liability for accidents in space, intellectual property rights for inventions made in microgravity, and the ethical implications of altering celestial bodies. The establishment of space courts also raises questions about enforcement. How will rulings made by these courts be enforced in the absence of a centralized authority in space? One potential solution is the creation of international enforcement mechanisms, where nations agree to uphold the decisions of space courts through mutual cooperation. This would require a high level of trust and collaboration among spacefaring nations, as well as a commitment to the rule of law in space. Moreover, space courts could serve as a platform for fostering international cooperation and preventing conflicts. By providing a transparent and impartial venue for resolving disputes, these courts could help reduce tensions between nations and private entities operating in space. This would be particularly important in scenarios where resources are scarce or where overlapping claims create the potential for conflict. As we look to the future, the creation of space courts represents a significant step toward establishing a fair and orderly legal system for space activities. These courts will not only address the immediate challenges of extraterrestrial disputes, but also lay the groundwork for a more collaborative and sustainable approach to space exploration. With this in mind, let's now explore how space law intersects with another critical issue: the ethical and legal challenges of ensuring human rights in space. As we bring our exploration of the future of space law and ownership rights to a close, it's clear that the next frontier of human activity will be shaped by a complex web of legal, ethical, and technological challenges. From the rise of international space governance bodies to the establishment of specialized space courts, each of the 25 predictions we've discussed highlights the critical need for innovative legal frameworks to guide humanity's journey into the cosmos. These frameworks will not only address immediate concerns like lunar property rights and asteroid mining regulations, but also lay the foundation for long-term issues such as space environmental protection, extraterrestrial human rights, and the ethical use of space-based resources. The potential impact of these developments on humanity's future cannot be overstated. As we venture further into space, the decisions we make today will shape the opportunities and challenges faced by generations to come. Whether it's ensuring equitable access to space resources, preventing conflicts over territorial claims, or safeguarding the rights of those who live and work beyond Earth, the field of space law will play a pivotal role in defining our collective future. But this is just the beginning. The evolution of space law is a dynamic and ongoing process, one that will require collaboration, creativity, and a shared commitment to fairness and sustainability. As we continue to push the boundaries of what's possible, it's up to all of us, governments, private companies, and individuals, to contribute to the conversation and help shape the rules that will govern our activities in space. So, what do you think about the future of space law and ownership rights? Which of these predictions do you find most compelling, and what challenges do you think we'll face as we navigate this uncharted territory? Share your thoughts in the comments below. We'd love to hear your perspective on this fascinating topic. If you enjoyed this deep dive into the future of space law, don't forget to like this video, subscribe to our channel, and hit the notification bell so you never miss an update. Together, let's explore the incredible possibilities that lie ahead as we reach for the stars. Thanks for watching, and we'll see you in the next